What is a surviving spouse's share in intestate succession? Imagine losing a loved one and wondering what part of their estate your family might inherit if they didn't leave a will. That's where intestate succession laws come into play. When someone passes away without a valid will, the law steps in to decide how their estate is divided among family members. The surviving spouse usually gets a big part of the estate, but exactly how much depends on who else is still alive. If there are no children or parents, the spouse often inherits everything. But if there are children or other close relatives, the spouse's share might be less. For example, if the decedent has children who are not the spouse's children, the spouse might get half of the estate. If the decedent has children from another relationship, the spouse's share can be about half, with the rest split among the children. When there are no children but the decedent's parents are alive, the spouse might get 3/4 of the estate. Sometimes, laws specify a fixed dollar amount plus half of what remains. It's also possible for the surviving spouse to claim an elective share, which guarantees them a certain portion of the estate regardless of what the law or the decedent's will says. These rules vary from state to state, so the exact share depends on local laws. The main goal is to protect the surviving spouse's financial security and make sure the estate is divided fairly among close family members. If there are no other heirs, the spouse usually inherits everything. But if others are involved, the spouse's share adjusts accordingly. These rules help avoid disputes and make sure the estate is distributed smoothly. So, the surviving spouse's share in intestate succession can range from the entire estate to just a part of it, depending on who else is still alive. The laws are designed to balance the interests of the spouse with those of children and other relatives, ensuring everyone gets what they are entitled to under the law.